From that prosecutor's point of view, we move on now to see things from the view of a defense counsel. Mr. Victor Opara is involved with the defense of some high-profile defendants. Here's how he assesses the performance of the judiciary in year 2018.
Well, in my honest opinion, I think the judiciary fared very well. There were challenges, of course, but if you are to score the judiciary, you may wish to agree with me that the judiciary scored. I'll give judiciary a pass mark. I would say that during the course of the year, there were several challenges, and the judiciary itself had to actually address some of those challenges. Challenges in respect to ensuring that judicial personnel manning our bench are fit to continue to administer justice from the bench. And if you look back, you will see that the NJC had to interrogate itself, interrogate the entire judiciary, and we had instances of some who are not found fit any longer to stay on the bench, being shown the way out. Others were reprimanded, and there's some others who had to respond to frivolous petitions from the public, from colleagues, were actually returned blameless. And you find a situation where there has been some kind of a consciousness, even within the judiciary, that it is a sensitive post and that those who are opportuned to dispense justice should do so without fear of favor. Now, you will notice equally that there has been a lot of hue and cry about delays in the administration of justice. You will find that using the powers of delegated legislation, various heads of courts have tried to make rules and practice directions aimed at fast-tracking justice. At the Federal High Court, you have the Federal High Court Practice Direction of 2013. At the Court of Appeal, you have the Practice Direction of 2013. You have the Fast-Track Practice Directions of 2014. You have the Supreme Court Practice Direction on Criminal Matters of 2013. You have the Election Petition Practice Direction. And you cannot really underestimate or jettison the input of the judiciary in ensuring that there has been considerable legislative intervention in reducing delays. You will see the fault alteration to the Constitution. You have the time frames now for filing of pre-election matters, compilation and transmission of record of pre-election matters, and even total determination of pre-election and even election matters. All these things are geared towards ensuring that delays in the administration of justice is brought or are brought to the barest minimum.
From the assessments of the judiciary, let's assess the executive. How well would you say that they allowed the judiciary do its job properly?
For me, the relationship between the executive, legislature, and the judiciary needs to be highly symbiotic. There has to be total cooperation among these three organs. And you will find that the judiciary, in terms of enforcing its judgments, will need a lot of support from the executive. There has to be political will to allow the judiciary function independently. It is not enough for the executive to merely mount independence of the judiciary without actually creating the necessary atmosphere and space for the judiciary to live up to its billing and live up to its name. Well, I will say that the executive needs to do more, particularly in the area of obeying to the letter judgments of courts. If the executive is not satisfied or dissatisfied with a particular judgment of any court, there are constitutional avenues of addressing this. You have the Attorney General, who is the chief law officer of the Federation. And the current Attorney General is a senior advocate of Nigeria who is highly respected. It is not easy to take the silk. So if you have taken the silk and you double as an Attorney General, clearly is expected that silky advice and silky submissions will be coming from that particular fault. And I believe that to that extent, the executive needs to listen to the Attorney General. The Attorney General needs to give proper, legally sound, and constitutionally, statutorily, and case law backed decision advice. Because at the end of the day, we are all stakeholders in this justice sector, and you never know what goes round comes round. So I feel sincerely that the executive needs to pay more attention in paying total obeisance to judgments of court.
I want us to also talk about issues of graft. You have a front row seat as counsel in some high-profile corruption cases, but how far-reaching would you say that the federal government's anti-graft war is?
Well, I must say to a large extent that the federal government has actually shown to a large extent commitment and political will to fight corruption. There's no doubt about that. I mean, with the arraignment and prosecution of high-profile individuals that we see that have come to play, you agree with me that there are certain people who are actually facing criminal charges today that you would wonder, are we still in Nigeria? And to that extent, you will see some level of political courage and administrative strength in ensuring that some of all these cases have come to the public space and have actually come to the front burner. But you see, it is not just about just filing cases for political purposes or maybe scoring political checkpoints. It's about you ensuring that before you take a particular person to court, you must have done your homework very, very well. And you must ensure that at least you have to a large extent a prima facie case against such person. And in terms of the prosecutorial zeal, I must say that the EFCC has demonstrated a lot of prosecutorial zeal. But then the corruption fight needs to be very, very embracive and very, very encompassing. The government needs to occasionally re-examine itself, perform some self-interrogation, and to see whether there has been ostensible, apparent, or actual selective prosecution of high-profile and non-high-profile defendants. And this is very important because the perception of the populace and the perception of the citizenry as regards your fight towards corruption must be taken very seriously.
Towards the end of year 2018, we saw the president of the NBA being arraigned in court on money laundering charges by the EFCC. Where do you stand on these arguments that the EFCC cannot interrogate the payment of fees received by lawyers?
Well, I must say that to a large extent, this matter is sub judice. I must be very careful in my comments regarding that particular sensitive issue. But I must tell you that clearly, aside from cases of constitutional immunity, lawyers are not immune from prosecution where a particular lawyer has committed an offense. The prosecutorial organs equally need to be very careful in dabbling into the professional fees of lawyers. So if I take professional fees from an alleged murderer who has not been adjudged a murderer at the point of briefing me, I can't even pass a judgment on that person. And I take professional fees and he pays me those fees. Will I have breached any rule of practice if at the end of the day after the trial, it is found out that this same person is adjudged a murderer? Will I now be expected to go and return all the fees paid just because he's been alleged to be a murderer and probably in the course of the murder he took 1 or 2 naira from the victim, which was probably not proved during the course of trial?
Very interesting perspectives indeed, but what do you think? Please feel free to share your views with us on any of our platforms. Be sure to also catch a repeat of the program or watch via our YouTube channel. I am Shola Shirley. Thank you for watching.